All right, Alyssa, well, if it's okay with you, I'm going to get started.
Yep, go ahead.
Okay, well, a few initial thoughts before we get going. First, I'm not sure why somebody who quotes Aristotle and Socrates would ask someone who quotes Billy Madison and Ricky Bobby to do a CLE. Monty Nealon did, and I appreciate that opportunity and hope someone benefits from this. Second, obviously, this CLE isn't going to win any beauty awards, as you can tell from the materials, but it is meant to be practical. So instead of talking theory, I've searched the recent decisions on the Work Comp Court's website, and I'm using those real examples. So I apologize in advance if you recognize one of your cases. And as every practitioner knows, there can be a million different good reasons why the case didn't shape up as you had hoped. So I'm not saying you necessarily did anything wrong or I could have done it better, but the judge did feel that the evidence came up short, and hopefully we can all learn from it. So finally, I guess third, I do like to brag that I've read every decision in order posted to the Work Comp Court's website since the summer of 2007. And so I like to think that's given me a good feel for the judges and an almost daily CLE on workers' compensation law. So I guess in a roundabout way, I'm just trying to say that for anyone wondering why they should listen to anything I have to say, I'm not just speaking from my limited personal knowledge and experience, but from what I've read everyone else is doing or not doing. And then finally, I did time this presentation a couple days ago, and it came out right at 57 minutes. So if you have any questions, hopefully we can get to them at the end, but I don't think I'm going to stop in the middle to respond to anything that gets typed in. And then the second, finally, unless you're a newbie, the first third of this presentation is kind of review and basic stuff. So for all the more experienced practitioners, please don't give up on me if the first 15 minutes or so sucks. So let's start with the basics of causation. In workers' compensation, you generally have to have an opinion from a medical expert establishing the nature of the injury and its causal connection to the accident. That'll generally be in writing because video and live testimony just costs too much and it's not required. We have Rule 10 in Workers' Comp Court, so you can just get your opinion in writing. And causation is, basic necessary element of your case. And so while I really try not to be critical of other attorneys, if you show up to court and you're having your trial and you can't point to your causation opinion, you did something wrong. You should have either gotten the opinion, dropped the claim for whatever injury you don't have causation for, or drop the case. There's no reason to show up in court if you don't have a causation opinion for whatever you're trying to get covered. That being said, there is a Fitz case out there somewhere that says you can take all the medical evidence as a whole and somehow come up with causation, even if there isn't a single identifiable statement that's sufficient, but I don't think that's best practice, even in Judge Fitzgerald's court. And then finally, you only have to get your opinion to a reasonable degree of medical probability or more likely than not. And I think that's important to keep in mind if you go in and talk to a doctor and they start hemming and hawing about not being sure. So let's get to the materials. Exhibit A is a medical record, is from one of my cases. And I think this is kind of a good example or learning experience. If you look at the top under HPI, which I take to mean history of present illness, it says she sustained an accident to her right hand at work on July 1st, 2016. That is not causation. When you go through a doctor's medical record, they usually follow SOAP, which is subjective, objective, assessment, and then plan. And anything in those first two, or in this case under HPI, that's just the doctor recording history, but that's not the opinion of a doctor, and that doesn't get you anywhere. So having a consistent history of injury is good, but it's not causation. At the bottom of this page, you'll see that there's an addendum section, and somebody must have asked the doctor to comment on causation. Nothing in that equivocal jibber jabber is causation, and it doesn't do you any good. And it perhaps hurt you because the doctor just said that, I think this is a guy, but he said that he can't say one way or another. So we're going to come back to this in about 40 minutes, but that is not causation. Exhibit B is kind of self-explanatory, just another example of not getting to the level of specificity or the magic words that you need to get causation. Exhibit C is closer, still not good enough. Dr. Mahalik kind of dances around the issue in the middle of that first page, but he never seals the deal. And then if you go down to page 3, Dr. Boland gets really close, but for reasons that aren't known to me, and this is the questionnaire that the plaintiff's attorney sent, he isn't even given the opportunity to give causation. At the bottom of this, there's a paragraph that the judge suggests questionnaires are disfavored, and in a genuinely disputed case, I agree, but there are a lot of times when the medical records fully support causation, but the doctors don't quite give it to you, and I think a questionnaire is all you need in those situations, but we'll get to that a little later. Exhibit D is a little bit more interesting than those first 3. Unlike Exhibit A, where the pertinent language was in the history section, here Dr. Crockett states fall and likely ACL tear at the time in the story section, which the judge explains is under the assessment and plan, which in the SOAP format is taken to mean that it is the opinion of the doctor. So in this case, the judge ended up not finding that opinion persuasive, but at least it was a causation opinion. So that brings us back to the title of the CLE, which is get it right, get it tight. So you not only have to get causation, but you have to get it tight. And example D is an example where they got it, but it just wasn't good enough. Moving on to Exhibit E. Here, Dr. McCullen offers a causation opinion. Then some sneaky defense attorney showed up at his office with a video that purported to show that the plaintiff did at work. After seeing that video, Dr. McCullen backed off his opinion, and the judge just didn't go for the opinion that he had previously provided to the plaintiff's attorney. So again, getting a causation opinion is a good start. But in this case, if you're going to suggest to a doctor that her job caused the injury, the doctor has to know what that job consists of. And I know this stuff is kind of boring, but I hope the last 40 minutes gets better, so stick with me. Exhibit F, and I think this is the most common shortcoming of causation opinions, at least the questionnaire types, is when the medical records don't support the opinion. So Judge Hoffert often states that he likes to see a consistent thread throughout the medical records, even if there is some variation or inconsistency. So here the judge basically said, yeah, you have a causation opinion, but it doesn't fit the story the medical records is telling. So if you have a causation opinion that seemingly pops up out of nowhere, you need to account for that or somehow explain how the doctor got there. A conclusory statement in a truly contested causation dispute isn't a strong hand, and that's where a questionnaire I don't think is sufficient. Exhibit G, this is an example of getting the causation opinion right and still losing. Here you have a guy with some pre-existing problems in his neck. Dr. Agostino acknowledges that and explains that the accident made the problem worse, which is exactly what he needed to do. He acknowledges the pre-existing problem, but says the accident made it worse. Here, the judge wasn't impressed with the accident that supposedly caused the injury, which was a relatively minor collision between a small pickup and a semi. In the driver of the semi was the plaintiff, and the judge just did not seem to be impressed with the plaintiff himself. And he goes through and kind of comments on some of the behavior of the plaintiff, and I think ultimately he must have had credibility issues. But this example, and then the next, illustrates some foundational deficiencies in the opinion. The opinion itself is legally sufficient, but the judge ended up not finding it persuasive. And again, I'm not dogging these attorneys because you're stuck with the facts that you're given, and obviously you can't change how the accident happened, and just do the best you can with the facts that you have. But Exhibit H, I hate to even talk about this because the plaintiff's lawyer did everything that she could for a guy that was really in bad shape and still ended up losing. In this case, the plaintiff had a truly disabling brain injury, and I think the defense was that the brain injury or brain problem was just early onset dementia. The plaintiff claimed it was from long-term exposure to carbon monoxide, and I haven't read the case for probably close to a month, but I think this guy was a yard jockey where he worked for UPS and pulled semi-trailers in and out of the dock doors. And again, the details aren't real fresh, but I think that he was alleging that the truck that he drove was a piece of junk, and he was allegedly exposed to carbon monoxide for a long period of time. Unfortunately, that truck was sold or recycled, or for some reason wasn't available to test. And further, nobody could state what levels of carbon monoxide the plaintiff was exposed to, or point to a blood test where plaintiff tested high for carbon monoxide. So the plaintiff's doctor that gave causation said what he needed to say, and it sounded plausible, but unfortunately for the plaintiff, the foundation of that opinion was shaky, and the defense attorney, frankly, just did a good job in attacking that foundation, and the judge was not persuaded. At this point, I'm going to take a step back and pivot from instances of people failing or coming up short to instances where plaintiffs were successful, and then continue on to suggestions on how to end up in that latter group of people. And before I do that, I want to state the obvious, which is the CLE is from the plaintiff's perspective, because that's all I've ever done. If I was a defense attorney, I'd basically just do what was pointed out as shortcomings above. First and easiest is check to see if there is a causation opinion. If there isn't, I mean, keep your mouth shut until trial. Invite in a representative of the insurance company or the employer to the trial, and then at the end you can point out the deficiency and strut around the courtroom like a rooster with a chicken coop full of broody hens. Love to be the hero. If there is a causation opinion, check to see if it's supported by the earlier medical records and the other records or statements of the plaintiff. If it isn't and you're feeling brave, you could try to convince the judge that while it's legally sufficient, it isn't persuasive, and therefore the plaintiff should lose. A safer bet would be to hire a DME and have him parrot those inconsistencies that you've found in the record, so that you're able to give the judge a choice between one doctor or another, and not just forcing the judge to dismiss the plaintiff's doctor's opinion as not good enough. And then kind of along those same lines, just look for foundational deficiencies. If a doctor says that a certain activity or occupation caused the injury and you aren't impressed with that, videotape the alleged mechanism of injury and show it to the doctor and see if it changes his or her mind. If a doctor has gone out on a limb to provide causation, you can ask them how they got there. How would that accident cause this injury? Is there medical literature to support your opinion, or are you just saying it caused the injury because the plaintiff told you that? If it appears the doctor's giving causation and he's unaware of previous unfavorable medical records, you can go in and try to flip him, or save it for trial and attack the persuasiveness of the opinion and explain to the judge that your DME is more reliable because your doctor had all of the records. His foundation is a lot more solid than the plaintiff's causation opinion doctor. Obviously, you have to pick and choose your battles because going in to talk to doctors costs money, getting DMEs costs money, and you potentially just end up digging yourself a deeper hole. But the examples we just went over do show where defendants were able to do a little bit of work and win an occasional case. So enough crazy talk about employers winning in workers' compensation court. Let's move on to what we can do to make sure that doesn't happen. I keep talking about getting causation opinions and was mean enough to provide real examples of people who didn't get it or didn't get it tight. But I haven't said what causation is, so let's go over that real quick and then move on from the causation portion of this CLE. So causation can be and should be really simple, and it just boils down to a physician, and physician is defined in the work comp book. You can use a chiropractor in the right situation, but it's when a physician states that the alleged accident produced the alleged injury or injuries. And note that I said produced. I try to stay away from caused as often as possible when talking to doctors about causation, oddly enough, but we'll get to that in a bit. When I was in high school or maybe college, there were a couple of pilots in Nebraska who were supposed to be doing some training in a passenger aircraft. Instead of doing that, at least one of them decided it'd be more fun to do full throttle stalls or barrel rolls or something that you don't usually do in a passenger plane. Unfortunately, they had a collision with the earth. That's one of the instances when you can just ask a doctor, did the collision cause the injury, which in that case was death. And that might even be one of the rare instances where you don't even have to have a causation opinion, but I'd never suggest trying that. Similarly, when young people who don't weigh 400 pounds and smoke 2 packs a day, when they have a significant accident, maybe in that situation it's safe just to ask the doctor if the accident caused whatever physical injury you're claiming. Those cases aren't worth spending too much time talking about because they either get paid or if they get tried, it's not because of causation. So that's the end of the causation portion of this CLE. And brings us to aggravations, which I think is more interesting and an area where there's a lot more dispute and an area where I think a lot of plaintiffs practitioners can get better at that, myself included. And I think this is an area that should encourage plaintiffs' attorneys, and I think we'd see more people trying cases if they fully understood and appreciated all of the good opinions that are out there. So we are going to start off the aggravation portion of this with a case. I'm pretty sure this is Tim Dowd's, and not to promote him anymore because his head is already big enough and he gets more than his fair share of cases, but he also recently got a perm total from Judge Coe that I think should be read by any work comp attorneys, or at least plaintiffs work comp attorneys who are hesitant to try a case. Now, that's not in the materials because it wasn't a causation case or aggravation case, but holy cow, look that up. It's from within the last couple of weeks. Anyway, Exhibit I is about as far as you can stretch the aggravation language in Nebraska. The plaintiff in this case had right shoulder problems for years, I mean, over a decade, I think, going back to 2007 when he had a shoulder replacement that was offered as a treatment option. He didn't end up having that shoulder replacement, continued working, and in 2011 had a workplace injury. 4 years after that workplace injury, he finally gave in and had the shoulder replaced. Now, for all you lawyers who piss and moan about defense attorneys getting on to be judges with the court, look this decision up on the website. This is a former defense attorney. I think it's Judge Martin. But if you work your case up and you've got the right facts, I don't think you should hesitate to try your case. If you look at the bottom of page 1 and look at that language, I mean, that's as favorable language and as powerful of case law as you're going to get on aggravations. The facts still have to be there, and if you look at the bottom of page 2, you'll see how the judge got there. And actually, I'm going to go back. I think this might be Judge Frederick. In any event, it's a defense attorney turned judge, and I mean, these facts to win on that is pretty good. And if you look at the bottom of page 2, you'll see how the judge got there. 10 years from the time he was first offered a shoulder replacement until he actually did, and 4 years after the accident, and was found compensable. To me, that's good stuff. Exhibit I, number 2, I just added this, and it's from last week. Dr. Cornett, who's becoming a familiar face in workers' compensation, opines that this is just a temporary aggravation. But then the next paragraph down, you see that the plaintiff's symptoms have been ongoing ever since the accident. So Dr. Cornett, if the plaintiff's symptoms haven't returned to their pre-accident level, how in the world is that a temporary aggravation? And I think that's basically how the judge got there. When you look down towards the bottom in the bolded language, the judge kind of just says that if this is a temporary exacerbation, where'd the symptoms, why haven't the symptoms returned to their pre-accident condition? And if you go back up, so in the first paragraph, Dr. Cornett talks about the MRIs being basically the same. For whatever reason, this plaintiff had a pre-accident MRI taken, there's a post-accident MRI taken, and they're the same, but the symptoms are different. And if you look at the aggravation language from the American Medical Association Guides to Permanent Impairment 5th edition, that's almost textbook verbatim the definition that the AMA uses, but we'll get to that in a second too. So hopefully all this has been a review, or pretty close to review for most people listening. But we're going to get to the part of the CLE where I'm going to share my thoughts on how to get causation opinions in situations where your client is old, fat, smokes, had a pre-existing condition, etc. And there's a good chance I think too much of myself, but this is an area where I think a lot of people need to do a better job and use the aggravation language from the case law from the AMA 5th. And get in there and get causation opinions from doctors that are persuasive, and you do get them tight where they're not easily attacked. And I also have to stop and say that this isn't anything I've come up with or any idea that is new. When I first came out of law school, which was only 8 years ago, Julie Shipman Burns was speaking at a CLE, and she was saying the same thing. You got to get in there and talk to these doctors, or send them a letter, do something to build up your case. And then in the last 2 or 3 years, Monty Nealon and Javo, or Mike Javronic, have done a lot to improve the questionnaires that I send out, and then also rules of the road. So I didn't really come up with any of this. But I am doing it, and encourage you to take the time to do this stuff as well. Exhibit J is an example of a questionnaire that until a couple of years ago, this is basically what I was sending out, and frankly, it's garbage. If you look at the top, first of all, questionnaire is spelled wrong. But worse than that, I mean, look at question number 2. I mean, I tried to incorporate the broad aggravation language into the question, but it sucks. I'm the lawyer that wrote this question. I'm still not even sure that it makes sense. Nobody talks like that, and it's a terrible question. Thankfully, in this case, it did work out, but I've gotten responses to these kind of questionnaires where doctors are crossing words out, or they're writing in question marks or circling a word or two, and I think that reduces the persuasiveness of a questionnaire, which some judges are already not very impressed with. So in order to get causation right and get it tight, and by tight I mean unassailable or as close to it as you can get, I think you need to either meet with the doctor and make sure he has a complete history, or write a letter laying out that history, and then laying the roadmap as to how the injury is compensable. So if you get a causation but you're too sheepish or too afraid of addressing the warts in your case, you might be wasting your time and opening the door for some defense attorney to weasel his way into the doctor's office and say, hey doc, did you know X, Y, and Z? And at that point, you've blown your credibility with the doctor, potentially tanked your case. In most cases, I think writing a letter is sufficient, but if it's a higher dollar case or one that has more warts than usual, but you still think it's winnable, just go in and talk to the doctor. I've had so much luck doing that. So Exhibit K is the type of letter I usually send to a doctor along with a questionnaire. I've shared this with attorneys in the past, and they've wondered if putting this in writing was a good idea because a defense attorney may get a hold of it. And my kind of response is I routinely produce the letters I write to the doctors along with a signed report from the doctor, and I hope they introduce it as evidence because it's basically my closing argument. You have to make sure that everything you put in there is accurate, but why wouldn't you want a judge to see this? If you look at the second page of Exhibit K, I kind of list what I send to the doctors. And you'll see that one of the things I included was the AMA 5th definition of aggravation, which I had talked about above. I don't really know the rules on copying and distributing that stuff, so I didn't do it, but I am going to read it to you because I think that there are people who aren't aware that it's out there. And when you're in talking to a doctor and you're getting some pushback, this is huge. So again, kind of boring, but stick with me for a second. So I think this is page 12, AMA 5th. I think most attorneys' offices or work comp attorneys' offices have this book, but if you look at page 12, 1.6c is the definition of aggravation, and it says, for purposes of the guides, an aggravation is a factor that alters the course or progression of the medical impairment. For example, an individual develops low back pain and sciatica associated with the finding of an L3, L4 herniated disc. The symptoms continue but are intermittent and do not interfere with the performing activities of daily living. A few years later, the individual twists his body while lifting a heavy package and develops constant, severe, acute low back pain and sciatica. Imaging studies show no change. Now, remember, just a few minutes ago, we were looking at Dr. Cornett saying the MRI doesn't show any change. AMA 5th, American Medical Association, Dr. Cornett says the imaging studies show no change in the herniated disc compared to earlier studies. The lifting is considered to have aggravated a pre-existing condition. Again, the only thing that happened or only thing that changed were the symptoms. That's an aggravation. That is enough. And so this is where in the description of myself for the CLE, I described myself as an admitted work comp nerd, and I got a couple people who asked me about that or questioned me about that. What I just read from the AMA makes me want to put war paint on and start running around screaming like William Wallace. I mean, what a weapon. You can march into a doctor's office and babble on and on about your stupid lawyer talk, or you can say, here, doc, this comes from the American Medical Association. This is their definition of aggravation, which is basically the exact same definition that we're using in workers' compensation court. There's no change in the imaging. The guy was previously symptomatic, but it is still considered an aggravation because the symptoms got worse. How much easier can we make this? Going back to Exhibit K, if I know how to do that. Okay, going back to Exhibit K, underneath the AMA 5th, you'll see that I brought in a case excerpt or included a case excerpt regarding Nebraska's causation standard. If you walk into my office on top of one of my bookshelves, underneath the bald eagle paperweight, America, I have a stack of excerpts on aggravation language from various judges pinwheeled. I have them for backs, I have them for necks, knees, whatever. And I'll take those into doctors' offices and try to use one from the judge that the case is in front of if I'm getting pushback. And to clarify, I only use the AMA aggravation language or case law if I am getting pushback. But I bring them with me just in case. And we'll get to this in a little bit, but ideally, if you're asking the right questions, the doctor will just say, agree, 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 or check, I agree, I agree, I agree, and I get out the door and don't talk anymore. But I went in and saw Dr. Bozarth, another familiar face, and I think he's a little more middle of the road than some people, but he is used as a DME, but a few years back I went in to get causation from him, and he was hemming and hawing, and I busted out 212-0905. Anybody who has a case with Bozarth in it, you need to look that up on the comp court's website. I mean, what a gem. How can he argue with himself? It's beautiful. And I don't think I included that, but 212-0905, look it up. It's helpful. Exhibit L is another letter that I sent to a doctor, and again, I pretty much lay out what I want him to say. I don't think there's anything unethical or dirty about it, because I'm only asking him to say what I really believe is the truth and what I think the medical records indicate. So Exhibit M is the typical questionnaire, and one that I recently sent out. I haven't even gotten this one back yet, so hopefully the defense attorney on this case isn't on the webinar, but I really don't know how much it matters or what they can do. If you look back at Exhibit A, that was the very first medical record we went over, where there was a recitation in the history section that would have been causation, except for it was in history, and then there was that addendum where Dr. Reddy just had some equivocal statements, but this is supposed to cure that. So you have to write questions that the doctor can't say no to, or that it'd be really hard to say no to without opening themselves up to getting throttled in a deposition. And that might sound hard, but if you have a winnable case, it really shouldn't be. If you look through this questionnaire, nowhere in it do I ask if an accident caused an injury, and this is where I kind of have to rant. You do not have to get a doctor to say an accident caused an injury, so you got to quit trying. When Usain Bolt runs a 100-yard dash or whatever he competes in, he starts at the starting line. He doesn't start 20 yards back, and it'd be stupid to do that. Same thing here. There's no reason to do anything more than you have to. Make it easier on yourself. Make it easy on the doctor. So flipping through there, you can look at the questions. I try to make it almost impossible to say no to. Where are we at? So Exhibit M, I might have gone too far here. Exhibit M is, in my mind at least, and obviously I'm biased because I wrote it, but I mean, that's almost perfect. How do you say no to any of that stuff? If you start asking a doctor or sending him a questionnaire talking about using the word cause, you're going to get pushback, you're going to get problems. Arthritis is not generally caused by accidents. Degenerative disc disease is just another term for arthritis, and it is not caused by an accident. Now, that does not mean that injuries involving arthritic body parts aren't compensable, but if you use the word cause, doctors will argue with you because arthritis isn't caused by accidents. Although post-traumatic arthritis is maybe an exception to that, but let's not confuse things here. So you don't use the word cause when you're dealing with arthritic conditions, and you also can run into issues where doctors want to argue with you just because they don't think that the injury should be covered by workers' comp. And those aren't arguments you're going to win. So avoid all that by asking questions like the ones in Exhibit M. N is the same thing. And I call these things walk the plank charts, because even an unfavorable doctor is going to have a hard time marking disagree as long as you're asking the right questions. And the farther down the chart they go, the harder it is for them to turn back. Again, the inspiration for this came from Ani and Javo in the Rules of the Road, as I'm obviously not sophisticated enough to come up with this on my own. But I do think I'm getting better at formulating these questions that are harder to mark disagree. And then I also will throw in some questions about the medical care being reasonable and necessary, just to stroke the doctors a little bit. As I stated earlier, I think these questionnaires are okay in fairly straightforward cases. And you can add some explanatory language like I did in Exhibit M to give the opinion a little bit more meat. So just having to check the mark or check the box report that doesn't really have any explanatory language in it can get you in trouble if it's a truly disputed case. My new favorite, besides work, are the causation reports in O, P, Q, R, and S. Exhibit O isn't that interesting, so I just wanted to give you as many examples as possible. But Exhibit P is on a guy who had a history of concussions and tinnitus, and I'm trying to get it compensable. So I didn't feel like a check the box questionnaire was going to be persuasive enough. So I just called and talked to the doctor for, I don't know, 6 or 8 minutes. Actually learned some things in there that weren't in the medical records. And voila, I have a narrative report of sorts. Judge Martin accepted her opinion. My guy's headaches got treated. He got some special hearing aids to help with the tinnitus. And that wasn't what I think was a close call, and one that I did not think was a slam dunk. But I think these kind of narrative reports or narrative-ish reports are really helpful. Exhibit Q, this is on a 70-something-year-old man. As I ranted about before, arthritis is in every 70-year-old man. You're going to need knee replacements even without injuries, and sending a questionnaire is potentially going to get you in trouble. So I called and chatted with him, got him to agree enough to get it compensable, and my guy got a knee replacement. Exhibit R, I had a DVT and stress fracture that I needed to get covered as a compensable consequence. As you can see, this is just a couple of weeks old, so I haven't tried this issue yet, but it looks like a winner to me. Exhibit S, again, this is another fairly recent one that was really helpful. I had a guy who had a granite slab fall on his leg at work, smoked his femur, just snapped it completely in half. Then 4 months later, he's sitting on a couch at his mom's house. He's an epileptic. He has a seizure, and then when he's done flopping around, he comes to, and his hip and his butt are hurting him. So they take him to the ER, they scan him, and he's fractured his femoral neck and needs a total hip replacement. So he calls and tells me about this, and I'm sitting at my desk and thinking a whole body injury sounds like more better and more chatter than an impairment rating. Plus my guy doesn't have the money for a hip replacement, so I'm trying to find a way to get this covered. The little gears start turning in my head, and I come up with a theory that he had a hairline fracture in his hip from the original injury that went undetected until the stress from the seizure caused it to snap. I got Dr. Hartman on the phone, UNMC orthopedic doc. I'm a little scared because I just spent a few $100 and I'm worried I'm going to get laughed at. But my commitment to my clients knows no bound. So I press forward. Talk to him. Dr. Hartman is not impressed with my theory. But in talking to him, he tells me he's almost certain he knows what happened. The rest is history. You can read for yourself what he said. So the femoral neck fracture and the resulting hip replacement truly were a compensable consequence of this original accident. None of that came out in the medical records, but I called and talked to him for 6 or 8 minutes. That case is going to get tried in April or May, so I don't know for sure that it's a winner, but it looks good. Looks good to me. So I hope that the takeaway from the aggravation portion is do not ask the doctor, did the accident cause the injury, if you are dealing with an aggravation, and don't ask doctors open-ended questions. I recently saw a letter from another attorney who wrote to a doctor asking about causation, and I hope he isn't on here listening because he's older than me, he's a better lawyer than me, and I'm sure that he's smarter than me, and I genuinely mean those things. Which actually isn't that much of a compliment, but we're kind of friends, so I would hate to offend him, but he asked the doctor for causation in a pretty complicated case and gave the doctor no guidance on how to get there. When I write to doctors, I leave no doubt about what I want him to say or how he gets there. If you look at exhibits K and L, and I wish I had more examples of letters I write, but the old saying that when I want your opinion, I'll give it to you comes to mind. If you look at those letters, I was upfront about the warts. I think I dealt with them. I provided complete medical records, including the pre-existing problems, so the opinion is foundationally sound and can't easily be picked apart. But if you have a winner and you need the doctor to say something, and provided that that's true, don't be shy about shoving the words down their throat. I've never tried to get a doctor to say something I didn't think was true or that I didn't think that he could easily defend. And that's important, because if you screw a doctor once and embarrass him in a depot, he'll never forgive you, and he shouldn't, because you're a piece of crap who's willing to bend the truth or tell half-truths to win a case, and that makes no sense to me, and at least partially accounts for attorneys' reputations, but I'm digressing at this point. So don't leave it up to the doctors to answer their questions. They answer the questions that you ask them. Be perfectly clear what you want the answer to be. So that concludes the causation and aggravation portion of the CLE. And now we move on to the final portion, which is adjudication. And for this CLE, I'm limiting that to the adjudication of causation and aggravations. As a general rule, I think the judges of the Workers' Compensation Court would agree that you have won or lost the case before you walk into the courtroom. Winning in work comp is hugely dependent upon the medical evidence. But if your client tells a consistent story about getting hurt at work, they're diagnosed with an injury that's consistent with that story, you should win as long as you have a causation opinion. That may sound a little too simple, but much like Charlie Daniels, I am a simple man, and I think that's a huge advantage over the intellectual and sophisticated types. When I read the Supreme Court language that says the accident only has to be a contributing factor to the claimed injury, I take that at face value, and that is all that I try to prove. Sticking with the track analogy I used earlier, for adjudication, when you're up in front of a judge, you need to set up a little tiny hurdle in your opening statement and then jump over it with your client's testimony and the medical records you introduced. I think your open, your direct, and your close should all be the same before and after story. Kind of repetitious, but say the same thing over and over again. And set up that small hurdle that you have to jump over. So to me, your opening statement, at least regarding the aggravation portion of your case, should be something like, the evidence will show Johnny didn't have problems with his knees before the accident, and now he needs a knee replacement. Or he saw a chiropractor for his back, but it never kept him from working, and now he needs a fusion. Or he had occasional neck problems, but the symptoms always went away. Now he's in pain every day, it isn't going away, and he needs surgery. Really simple, really short. I'm regurgitating what we've all heard at CLEs for years. But that simple and short before and after story is a winner. I would also suggest that you have to bring up the warts in your case first, frame them in the best possible light, and then show how the accident made it worse. If you ignore the warts in your case or try to unfairly minimize them, I think you're screwing yourself. Your direct, again, I'm just talking about the causation or aggravation portion of your case, but it needs to follow that simple and honest before and after story that fleshes out what you said in your opening statement. Your client testifies that 3 years before the accident, he had a knee injection, but then after that, he worked for the defendant for 2 years without missing a day of work for knee pain. He was in golf league, whatever. Or maybe he worked without restrictions and passed a pre-employment physical and was walking fields hunting pheasants every fall. Now, since the accident, his knee is killing him on a daily basis. He can't work. It needs to be replaced because the injections just aren't cutting it anymore, and that's different than before. Before the accident, the injections cured the problem. Now that's not good enough anymore. That's a difference. Not to belabor the point, but his back was bothering before, but his back was bothering before, but he was getting along okay until the accident at work. Now the pain has gone from something that was nagging and something that he could live with to excruciating, and no way he can work with it, and he can't even mow his yard. So you got to find whatever facts you can pre-accident that support your position that whatever problems he had were either asymptomatic or the symptoms weren't that bad. And then ask the questions that allow your client to tell that story of somebody who was getting along okay. and then the accident took place, things changed, and then you drag out the parade of horribles and the medical records, his personal life, etc. Combine that with a doctor's opinion that says that the accident made the symptoms worse, aggravated the arthritis, put the finishing touches on an already bad back, or whatever your case is, and you should have a winner. Before and after, compare and contrast, keep it short, keep it straightforward. Facts obviously have to be there, and we very early on saw some cases where maybe the facts just weren't there, but that's a case selection issue and not part of this. I can tell you when I hear facts that sound like aggravation, I get excited because you're already dealing with somebody who was messed up before. Now they're even more messed up, and that sounds like a bigger impairment rating, more restrictions. In other words, an opportunity for me to really help someone in need. The last exhibit is Exhibit T, and this is something I have just started doing within the last few months to try and help tell that before and after story. This is a case with a 70-year-old client. This is a different one than before, but I'm arguing he needs a knee replacement due to a workplace injury. My simple strategy is to explain to the judge my before and after picture about how his knee was doing fine until the accident, even though he's 70-something years old and obviously had pre-existing arthritis. Now, there's a law firm in Lincoln, it rhymes with Baylor Evnen, but they must get paid a fortune to review medical records because they are very thorough in requesting records. I mean, for example, 6 or 8 months ago, I had a client who was 40-something years old, and I had medical records that I was reviewing from when he was 6 or 8 years old and fell off of his bike. I currently have a copy paper box filled with crap that they sent over on another case, and there's literally over 3,000 pages on this one guy. So a few months ago, I'm looking at all this crap in my office and thinking of a way to use it as a weapon, to wrap it around their neck and yank tight. I obviously can't introduce all of this as an exhibit just to show the judge that he wasn't treating for knee pain before the accident. But I thought, you know what, I can bring it to court, stack it on my table, and show the judge, along with the request for admission in Exhibit T, that, Your Honor, the defense attorney just absolutely scorched earth the state of Nebraska looking for medical records. They've gone back 10 or 15 years, and you're going to see when you look through their exhibits, they did not find any pre-existing problems. Despite the fact that we have 600 pages or whatever this says. I guess it just, Exhibit T, the request for admission, just says hundreds of pages. But you can certainly stack it on the table in front of the judge and say, Your Honor, this is all the stuff that they requested, all of his medical records going back 10, 15, 20 years. And when you look through the exhibits, you're not going to find pre-existing complaints. So yeah, he had arthritis in his knee, but in the last 10 years, he did not go to the doctor and complain about it once. Now, I haven't actually done this yet because I just thought of it, but I do think it's a useful tool in demonstrating the before and after story. Now, you know, those Baylor lawyers are smarter than me, so it'll probably end up backfiring, but I am going to give it a try. For one, I'm sick of sorting through all that crap, and for two, I do think it's powerful to have that stack of medical records and say, hey, judge, all this is his pre-existing medical history, and none of it shows medical problems for the knee or the back or whatever you're in court complaining about. So in any event, so that's your direct and that's your medical evidence. Your close, at least regarding causation and aggravation, is just a repeat of your opening statement, indirect. Your Honor, Johnny didn't have any work restrictions because of his back before this accident. He went to work every day. And yeah, he occasionally went to the chiropractor and he had an injection 2 years ago, but life went on. Since this accident, he hasn't been able to go to work. He's in pain 24/7, and the doctors are telling him he needs surgery. When you review the exhibits, you'll see a stark difference in those few medical records that predate the accident and all the post-accident medical records, including the opinion of Dr. Smith in Exhibit 6, page 7, that I highlighted for you, where he acknowledges those pre-existing problems, but believes the accident has aggravated Johnny's degenerative disc disease to the point he needs surgery. So again, I know I'm belaboring it, but this is the exact same thing that I do at trial. Opening statement, your direct examination, all of your medical evidence, and your closing argument is just the same thing. You set up that tiny little hurdle that this accident made whatever injury he has worse. You jump over that hurdle and you're done. Hit those highlights, address the warts first, and rehabilitate your client on direct examination. I kind of do a mini cross-examination in my direct examination, because then when the defense attorney stands up and he's doing his cross-examination, you've already talked about it. It's old news to the judge, and it's not interesting. So do that, get out the door. I can tell you that most of my trials are less than an hour, and I doubt that they've ever gone over 2 hours. As I stated earlier, as a general rule, your exhibits are going to either carry the day or doom your case. So getting up in front of a judge and blabbering for 4 hours, I don't think is going to get you anywhere. So spend that time and energy pre-trial and impress the judge with your well-prepared and succinct trial. So this is going nowhere fast, so I'll wrap it up. I apologize to all you suckers that paid $50 for this, but it does go to support the Nebraska State Bar Association, so it isn't a total loss. Hopefully most of you got it for free. If you have any questions or any suggestions on ways to do these things better, feel free to chime in or email those examples to me. And that's all I got. I've not seen any questions come in, and I do see that I'm about 7 minutes short, and perhaps I have talked faster than I did when I was timing it on Tuesday, but hopefully somebody can come up with questions so that we can drag this out until 1 o'clock. Trying to come up with anything more useful that I can talk about to fill time. I guess I would go back to getting in and seeing doctors or calling them. That's what I've been doing lately. If you go back, I think it's QR, S, and O, or the exhibits where I just summarized the conversation, sent that summary of the conversation to the doctor. He signs it, and then I submit it as an exhibit at trial. Those conversations are very useful. I mean, as lawyers, we sit and read medical records all day, so we think that we know a lot or think that we have the client's injury figured out, but you can still learn a lot from doctors, develop some kind of rapport with them so they know who you are, and develop a familiarity so that when they see your questionnaires coming in, they know who you are and trust you, or are more willing to help you out when you need it. But it's really been helpful for me. Those questionnaires, I think, are golden. Or I'm sorry, the summaries are golden. The questionnaires, like I said before, are helpful in fairly straightforward cases, or where you just need a little bit of meat to corroborate your theory of the case. But those summary conversations, I mean, you can talk to the doctor for 20 minutes and have a 2-page summary if you need to, and address all of the warts, whatever persuasive medical testimony that you want to get in. You can include all of that in the summary conversation, have him sign it or her sign it, submit that, and I think it is really persuasive. It goes beyond the questionnaire that some judges have expressed a skepticism in, and I think they're golden. So I hope the examples that I provided have helped you. I've provided all the stuff that I use on a daily basis, and like I said, I don't know that other people aren't doing things better than I am, but I think these things are helpful. I apologize for my presentation not being as pretty as some other people's, but I do think that it was practical, useful stuff that everyday practitioners should be doing. So I have not seen any questions come in. So I plan to sign off. You can email me if you have questions, concerns, or any further comments. So have a great day. Hope somebody benefited from this. Talk to you later.